groups of ours. Thanks for that. And then after that, we'll hear from our very own Center for Food Safety, who's one of our members and has spearheaded a lot of litigation that we've been involved in our Don't Cage Our Oceans capacity as well. And so we're going to go ahead and I'll just give you the names of the folks who are going to be presenting. I'll do a quick intro on the lay of the land, and then I'll pass it over to Sky. So I'll go first, then Sky with FarmStand. Just wave. So Sky will go next. She'll do a good intro to litigation as an advocacy tactic. And then we're going to hear from Heather with Conservation Law Foundation. Heather, go ahead and wave. All right, there. And yes, it's being recorded right now, Faye. And then she's going to talk about litigating against corporations with a focus on the recent Cook lawsuit, Cook Aquaculture of Canada. And then we're going to hear from George with Center for Food Safety. George, there you go. All right. And he will tell us mostly about all the litigation experience CFS has had against government agencies, with a focus on the longstanding history that CFS has brought to the table with aquaculture cases, and really laying the scene for a lot of the, I guess you could say, precedent that we're relying on today. So thank you all for joining. And again, if you're an attendee, drop your name and affiliation in the chat. And then, if you feel comfortable, and we'll go ahead and get started. So just quickly laying the land here. And I have Casey and Adriana joining with me here today at DCO2, several folks like Fanny and Pedro with NAMA. We're looking at this from a very unique perspective now. So I'm going to fill you all in case you haven't heard of the Chevron doctrine, what that's all about, and what the hell Loper-Bright is about, right? So we're going to back up to Chevron v. NRDC, a case that basically held what's now colloquially referred to as Chevron doctrine or Chevron precedent. Basically, the idea that we should just rely on federal agencies who are the experts in the field to basically iron out the edges. When there's any sort of ambiguity in a law, let's let the agencies take care of that. We'll let them decide how to most sensibly address an issue and create rulemaking under various laws such as the Administrative Procedure Act and so on. And so there's a fair amount of agency deference, and I think it's it's the almost every aspect of what that agency deference meant has been litigated. But by and large, the contours of it were just saying, look, as long as you're not arbitrary and capricious or otherwise not in accordance with the law, basically, in layman's terms, if you didn't make some batshit crazy decision and how you got from point A to point B, we're just going to roll with it. The courts are not going to second guess you. You as an agency are the expert. We, the judiciary, we are not the experts. Why would we know? So long story short, lots of years of precedent were sort of laid on that, and a lot in the environmental world rested upon, a lot of case law rested upon this precedent. Now, even before, and this is just sort of dropping a little cookie crumb here for George to pick up on later, even in this world, there were still instances where an agency went so far out of bounds, there was no such thing as any authorization under any statute from Congress, that the courts did slap them down and said, look, this is totally rogue behavior. This doesn't belong even in our Chevron world. Now, last year, there was what's known as the Loper-Bright decision. It was two different fisheries cases rolled into one, collectively known as Loper-Bright. But basically, the facts of the case don't actually matter for the overall impact that this case has on the entire landscape. But real quick, it was the whole idea of NOAA, the agency under Commerce, or specifically National Marine Fisheries Service, NIMS, requiring observer coverage on vessels, yet not providing the funding for those observers for those fishing vessels. This went, all the way up to the Supreme Court. These were, of course, very friendly plaintiffs. It's you do want to sort of side with fishermen being hit with a new reg, but no way to pay for it. Like, that's not fair, right? And so, for better or for worse, other groups jumped in on this and found an opportunity here to essentially overturn longstanding Chevron doctrine precedents, right? And so now we are in a landscape where agency deference, or the court's deference to agency rulemaking, has just been tossed aside. So now we're in a situation where it requires like the court is now emboldened to take a look and say, well, this doesn't make any sense to us. We may not be the experts here, but now under this Loper-Bright world, we can second guess what an agency has done. And now this cuts many different ways. In most instances, environmental groups writ large think this is bad news, and rightfully so. There's a lot of EPA clean air, clean water regs that have been put in place that most people agree were good for the environment that now can be second guessed. And then on the flip side, when we're talking about aquaculture and when we're talking about rogue agency action and the sense of regulating aquaculture when there's no statute authorizing that, in some ways, we're actually even in a stronger position than we were before Loper-Bright was decided. So I'm just putting all that there as a setting the scene for this conversation. And now I'd like to turn it over to Skye from FarmStand. So go ahead and take it away, Skye.
Sure. Thanks, James. I think Casey's going to work. Oh, perfect. I was going to say Casey's got a slideshow for me. Can you all hear me well? I just wanted to double check. Sometimes I have tech issues. Good. Well, hello. It's so great to be here today. My name is Skye, and I'm a fellow with FarmStand, formerly known as the Public Justice Food Project. FarmStand is a legal advocacy organization that primarily uses litigation to dismantle our current system of industrial agriculture, which, as all of you know, is very exploitive and extractive. So we use litigation to change the system. So today I'm going to be talking about what litigation is, just kind of from a high level. I'm going to talk about how FarmStand approaches litigation and why it's a promising tool for creating systems change. And then finally, I'm just going to share a few ideas for using the law to dismantle industrial aquaculture. So what is litigation? Some of you may know this. Litigation is the process of resolving a dispute in front of a court or an administrative body. It involves filing a complaint, presenting evidence, and arguing your case before a judge or jury. Traditional litigation is a little bit different than what's known as impact litigation, and I just wanted to make that point. So they both use the same process, but they have different objectives and strategies. So with traditional litigation, the purpose is usually to vindicate the legal rights of the particular parties that are before the court. So for example, if Google is suing Microsoft for patent infringement, Google and Microsoft are the parties, and the relief granted by the court is usually, it impacts just those parties alone. The case doesn't have a broader impact beyond that particular dispute. Impact litigation, on the other hand, is meant to achieve far-reaching and lasting effects beyond a particular case involved. So oftentimes NGOs use impact litigation as part of a broader advocacy campaign designed to raise awareness about a particular issue, build power, and create systems change. There are two, I think James alluded to this, there's two kind of flavors of impact litigation. There's suits against the government, and there's suits against private actors. So in terms of suing the government, oftentimes NGOs will use administrative law, and they'll sue a state or a federal agency for that agency's unlawful action or their failure to act altogether. So for example, it could be the state approving a permit to put a new facility in without actually considering all the environmental impacts that decision will have. Or it could be, the EPA sitting on a citizen petition for a decade and not taking action on it when by law they're supposed to within a reasonable amount of time. On the flip side, you have suits against private actors. So this could be targeting individuals or targeting businesses for their violations of the law. And claims can be based on the Constitution. They can be based on federal statutes like the Clean Water Act or state statutes and regulations. And then sometimes those are also based on common law, which is just a fancy term for judge-made law. So when you see claims like nuisance and trespass, and negligence, those are often presented as common law claims. And if you would go to the next slide, Casey, that would be great. So FarmStand has kind of a unique litigation model, and I wanted to just talk about that a little bit. So FarmStand brings impact litigation to build power in communities and to shift the narrative, recognizing that the law was created by those in power, so it's not always a means to achieve justice, but it can be a really effective tool at doing that. So FarmStand also has a pretty diverse docket. So we strive to kind of highlight the shared goals of different movement sectors, bringing all of that together. We do environmental cases, we do antitrust cases, we protect workers, we bring suits in a lot of different areas. We sometimes use consumer protection as a tool. I'll talk more about that in a minute. But we definitely think it's important to sort of highlight the intersectionality of these areas because we're stronger together, right? And then lastly, FarmStand tries to fill gaps when possible. So oftentimes there's gaps in the types of cases that people are taking on. We tend to take on less of the admin style cases against federal and state agencies because traditionally that has been well covered by other groups in our movement. And similarly, one of our focus areas is protecting the rights and interests of food system workers, not just because it's important, but because it's received a lot less focus and attention than other issues like climate and the environment. Next slide, please. FarmStand sees litigation as a really, really valuable tactic, and there's a lot of reasons for that. So for starters, litigation is just storytelling. Throughout the course of a case, there are a lot of opportunities to reframe issues for not only the court, but for the public. Litigation is often covered by the press, so it's a way to obtain, wide distribution of allies and clients' broader stories. Additionally, it can be used to set favorable legal precedents. So what I mean by that is it can be used to clarify, develop, and change the law so that it aligns better with our policy positions. A really good example of that is ag-gag. So in case you aren't aware, many state legislatures in the past decade have passed ag-gag laws, which make it illegal to expose what happens inside factory farms and slaughterhouses. They effectively stop people from collecting information and reporting on harmful practices. FarmStand has worked with a broad coalition to try and strike down ag-gag laws and has been successful in doing that, setting really, really important legal precedent that those laws violate the First Amendment of the Constitution. And for that reason, they're unconstitutional. They shouldn't be on the books. Litigation can force results. So oftentimes agencies and businesses just are not motivated to take action on something until a lawsuit is slapped across their desk. It's unfortunate that's the way it is, but that's the way it is. So litigation can be a tactic to force results when other tactics like, say, public campaigning or political lobbying just aren't effective and aren't getting us where we need to be. If you could go to the next slide, Casey. So another really important point is that litigation builds power on the ground. So just continuing with the ag-gag example I was talking about a minute ago, those legal wins have been really, really powerful in helping build resilience and power among local grassroots groups that are using those wins to not only to fight big ag, but to connect that litigation to their broader campaigns, which has enhanced their ability to organize and expand membership. So that can be a really powerful tool. And then finally, litigation can be really powerful for information sharing purposes. So sometimes in litigation, we can uncover and we can make public information that we obtain through discovery. And discovery is just the information sharing stage of a lawsuit. It's where I can request documents and data from the other side and use it to make my case. So in 2016, FarmStand actually partnered with the Animal Legal Defense Fund and with a couple of other private firms to sue Hormel, which is a really big agricultural player in land-based ag. And we sued them in DC over their natural choice marketing, which we argued was false and misleading. And really importantly, the discovery process in that case shined a spotlight on the materials that really painted a damning picture for Hormel in terms of what their actual practices were and their intentional and targeted exploitation of consumers through this marketing campaign. So FarmStand was able to get that information from the other side that wouldn't have been accessible to the public to begin with, compile it all, and put it on FarmStand's website for anybody to see. So it can be really powerful in that way. Go ahead and go to the next slide. So using aquaculture in the litigation space, I just wanted to discuss and sort of take your temperature on a few ideas. So at FarmStand, we've been brainstorming how to get at the issue of industrial aquaculture and everything that comes along with that, the awful environmental impacts, using the Clean Water Act and using false advertising. So those are two really promising tools we think, we feel very optimistic about. So on the Clean Water Act side of things, Heather will probably talk about this more in her presentation, but many aquaculture facilities have a permit under the federal environmental law, the Clean Water Act. And that permit limits the type and amount of pollutants that they can discharge into the ocean or into rivers and streams, whatever the waterway is that's receiving those pollutants. And permit violations create liability for producers. And the Clean Water Act allows citizens to step into the government's shoes and sue violators in court when the government is sitting on its hands and not actually enforcing anything. So it's possible we could bring an enforcement case against onshore and offshore aquaculture farms that are violating their permit, of which there are many, by the way. And then the second category is false advertising cases. So we know that you guys are doing a lot of really important work in Maine, for example. Perhaps we could build upon those efforts and target Cook or an entity like Cook using false advertising law. Now, to prove that a company's claims are false or misleading, you have to show what the actual practices are, and then you have to show how those differ from the company's public claims. So false advertising cases can be really, really beneficial because they allow us to sort of look under the hood and uncover what a facility's actual practices are. And then we can use that information not only in the litigation, but outside of the litigation as well for other purposes. So yeah, those are a few ideas we had. If you have thoughts or feedback, please contact me or anyone at FarmStand. We'd love to hear from you on that. And I think that's all I have today. So yeah, I really appreciate you listening, and please feel free to reach out to me or, like I said, anybody at FarmStand with questions or thoughts. And with that, I will turn it over to Heather.
Thank you. Hi, everybody. I'm Heather Govern. I run the Clean Air and Water program at CLF, Conservation Law Foundation. I work out of the Boston office. But, I think if you go back, there you go. Thank you. I work out of the Boston office, but Conservation Law Foundation has offices in each of the New England states. Our focus is just on the New England region. And if you go to the next slide, by the way, sorry, go back to the first one. I just wanted everybody to know, a lot of people haven't been in courthouses. So this is what the Moakley Courthouse in Massachusetts, the federal Massachusetts courthouse, and all the courtrooms look like. For some reason, we have this rainbow design in all the courtrooms, which I think they thought would make it more pleasant. And that's where many of CLF's cases are filed, but we do file federal cases and state cases in all the different New England states as well. Okay, next slide. Thank you. You might not know CLF. We have a number of different focus areas, and I wanted to put these in here to show you that I am only going to be talking about what the Clean Air and Water team does, but we have an oceans program, we have a climate change energy program, and then we have a group called Strategic Litigation, which is bringing cases against big oil and gas companies. So there's a lot of litigation happening at our group. We have about 150 staff, and I'd say probably 70% are attorneys. So we do a lot of legal work. Okay, next slide. Thanks. So yes, I'm going to talk about a case that was just filed in Maine's federal court last week, the 14th, January 14th, 2025. And we decided to sue Cook Aquaculture under the Clean Water Act. These are just some of the cages that are near one of the islands in Maine. You can go to the next slide. Thanks. And the subject of the lawsuit includes all 13 active cage sites that Cook has. This is the Maine coast. At the southern point, you can see how close some of those cages are to Acadia National Park. And then the cages stretch all the way up towards the Canadian border near Cobscook Bay. And of course, further north is where Cook has many other cage sites in Canadian waters, but we, of course, can only sue regarding those that are and among the state of Maine and in the state of Maine's waters. Next slide. Everybody probably knows the issues on this call regarding what these aquaculture finfish net pens produce, but here you go. You've got your, and this is, I'm getting to the point where to say that everything that's in this picture is a topic and a subject of the lawsuit itself. So you've got the fish feed going in and the chemicals, actually, except for the light and noise. I don't think we have a claim regarding light and noise, but the structure, the antibiotics, parasites, wastes, and then the escaped fish, of course, which we are arguing any escaped fish, also some of the parasites and any chemicals affect the dwindling Atlantic salmon population, endangered in wild Atlantic salmon population. Okay, let's go to the next one. So here we are. Here's just a little cut of our complaint. And this is our federal complaint in Maine that we filed last week. So you've got 7 counts. It's a doozy of a complaint. I think it ended up being about 42 pages. We did not include ESA, and I can answer that question later as to why. It would have been ESA is a very difficult and an additional statute that we weren't ready to include in this case right now. And I can get into more detail about that, but I wanted to show everyone, because I'm going to be talking a little bit about San Francisco v. EPA, which is the Supreme Court case that we are awaiting a decision on. And not we, but the entire nation is awaiting from SCOTUS. This is one of the first case that I've ever brought, and certainly I think CLF has brought, where we include narrative standard violations. So that's why I listed. So count 1, you can see I just pulled paragraph 329 from the complaint. There is a prohibition on floating solids that impair the designated uses of the water. And of course, Cook is discharging floating solids on a pretty regular basis. And it's listed there what it is: the plastic feed bags, the ropes, some pipe, and other plastic waste. And so that constitutes a violation of that narrative limitation there. So, but in addition to narrative standard violations, as you can see in count 3, count 4, 5, 6, and 7, there's other violations of their permit, actual numeric limitations on sediment that they're violating. They're discharging pollutants that are not even authorized by the permit. They're discharging not just from their cages, they're discharging from the docks where they operate off of. And they are really bad at how they sample. So we found a ton of errors in how they're doing their sampling and their monitoring. Okay, next slide. So what's the status of the case? We are in settlement discussions right now. There's been the start of some exchange of what's called informal discovery. That's where we haven't jumped into meeting with the judge and having status conferences and going through next steps in the case yet. There's been no briefing or motion or answers from the defendant. So we're able to just have what's called an informal exchange of information. And that's happening at the moment, and we're going to delay service of the complaint. Once we serve the complaint on the defendant, that starts the clock where they have to respond to the complaint within a certain amount of time. So we're going to determine first whether there's the possibility of settlement, and if that is not fruitful, we will formally serve the complaint. Okay, next slide. All right, so I wanted to quickly touch on another case that CLF brought 2 years ago, more than 2 years ago now. This is called, well, the title is CLF v. EPA. We sued EPA over not determining that there were stormwater discharges causing water quality violations in these 3 rivers in Boston. So the Mystic River, the Charles River, and the Neponset, and you can see the watersheds on the map there. This was a successful venture because we filed the complaint. It was to push EPA to issue a permit for stormwater discharges from certain commercial and industrial and residential at the time facilities. And if you go to the next slide, the result of that case enabled, well, I guess forced EPA to issue a draft general permit. So this is called an RDA permit. This is under the Residual Designation Authority within the Clean Water Act. So this is a rarely used provision of the Clean Water Act. And so there is a public comment period on this permit that has been extended to March 17th, so only 2 more months. And we will see what next steps are in this matter. I think I bring it up because we were successful with the past administration in getting Region 1 of EPA to issue a permit, or a draft permit, I should say. I don't know how successful we're going to be in pressuring Region 1 under this new administration to actually issue a final permit. So normally what happens is after the comment period ends, that's when there's responses to the comments that come out from EPA, and then there is the potential for litigation over the permit. But there has to be a final permit issued post comments, and I just am not optimistic at this very moment that we're gonna see a final permit, but we'll see. Okay, next slide. All right, so here's where we are with San Francisco v. EPA, and this is what keeps me up at night, because you saw in my case against Cook Aquaculture, we have I'd say about 50% of that case revolves around our narrative water quality standards and the violations. So if anyone listened to the oral arguments, it's looking likely that this court will strip the EPA of using narrative or incorporating narrative water quality standards into NPDES permits, the federal permits across the country. So if you go to the next slide, I just wanted to talk a little bit about some of the really great amicus briefs that were filed in this case, and point out some key arguments that were made. So you can go to the next slide. So the first is, and this is a case brought by San Francisco, the city and the county, and the state of California does not agree with what San Francisco is arguing. And San Francisco is saying that we cannot be restricted or regulated with these generic, they call them generic narrative standards that say things like you shall not deposit solids into the Pacific Ocean, right? You shall not change the color of the water. They are arguing, San Francisco's arguing that those are too difficult for them to comply with those standards. State of California says different. They say that these are complementary provisions. They have to be combined with effluent limitations, so those numeric limitations, in order to protect the water and to meet the goals of the Clean Water Act. Yep, you can go to the next slide. That's fine. So we had the environmental organizations amicus brief that was submitted by Earth Justice. CLF signed on to that. And one of the arguments from San Francisco was that how can we comply and how can we be safe from enforcement actions where there could be billions of dollars at stake. And so one of the arguments made in this amicus brief was that enforcement actions that allege violations of narrative water quality standards are not common, which is absolutely true, because my team did a full search before we filed our Cook Aquaculture complaint, and there are very few cases out there that include violations of narrative water quality standards. Certainly the government has not brought many. I think something like 10 cases in the past 6 years have included some violations of narrative standards. And then there's a little bit of information here about just how many facilities are covered by NPDES permits. This 300,000 is a little outdated. I think it's 330 or more. And by the way, the case was brought by San Francisco regarding their wastewater treatment system. So out of the 330,000 NPDES permit or permittees, only about 16,000 of those 330,000 are wastewater treatment facilities. The rest are other, usually private companies. Okay, next slide. And then finally, there was a brief amicus brief that was submitted from the small businesses that those were businesses that rely on clean water. So we had a lot of aquaculture, shellfish companies. I actually helped work on this brief. We had lobstermen from Maine. We had a San Francisco fisherman who submitted a lot of facts and great details about how important these standards are to protect their business. And the points made in this, very good arguments made in this brief, if I may say so myself, were that the numeric effluent limits are sometimes the only means of water quality protection in a permit. There are permits out there with 0 numeric limits. And then the other point made was that with climate change, we have seen so many weather events that have caused changing conditions in water bodies that and these are changes we've never seen before. So a permit that is often outdated, many are outdated. I think about a third of the NPDES permits out there right now, I'm probably being generous, it's probably more than that, are expired. And sometimes those permits are expired for 2 years or 5 years, sometimes 20 and 25 years they've been expired. Now think about all the science 20 to 25 years ago that was used to create all the standards in that permit that is now oftentimes outdated and needs updating. So you must have, so sometimes those numeric limits are just not enough, and you need to be looking at the water body itself and see if there's any changes to it, which is what's encapsulated in a narrative standard. Okay, next slide. I just wanted to quickly show you some NPDES permits. Go ahead. This is a zinc galvanizing plant. Does anybody see if there's a zinc numeric limit in this permit? There is not. And so this is just an example I like to give to show that sometimes the most important numeric limit that you could possibly need in a permit is not there, and you need a narrative standard that might assist in keeping the receiving water at a real high water quality state. So you'll see that at the bottom, there is a narrative standard listed. It says the discharge shall have no sheen. There shall be no discharge of visible oil, floating solids, or visible foam in other than trace amounts. And so that gives you an idea of what a narrative standard looks like in a permit. Okay, you can go to the next slide. And then here is no longer active permit, but this is the permit from one of the open ocean salmon farms out west in Washington that had 0 numeric discharge limits, only narrative. All right, I think I'm done. If you want to go to, yep. So I just wanted to give my prediction for San Francisco v. EPA. I am worried that we won't have any narrative standards in NPDES permits after a decision by the court. My optimistic view is that only under specific circumstances can EPA or any of the designated states or delegated states, excuse me, will be able to incorporate the narrative standards. So we will see. I think that's it. Thanks.
Thanks, Heather. We're going to turn it over to George, and I just want to flag for everybody who's on this call that we're going to try to wrap up the content by 4, but our panelists have graciously agreed to stay on for a few extra minutes if there's any Q&A after that. So if folks are able to stay past 4 p.m. Eastern, the top of the hour, that would our panelists will be on as well. Go ahead, George.
Hi, can everybody hear me okay? All right, great. So I'm George Kimbrell. I'm the legal director, co-executive director of Center for Food Safety. My slides are not pretty, so I'm glad Sky and Heather, the other participants, panelists, had pretty slides. Not known for that necessarily. This is also a topic that, I have often, when I teach food and agriculture law in law school, we'll spend a whole 2-hour session on. And so I'm going to do what I can in 10 minutes here, and happy to answer any questions. And obviously you'll have the slides afterwards. But yeah, I mean, like FarmStand, I think it's fair to describe CFS if you don't know who we are. And I put 2 links in the chat because my slides don't have a kind of nice overview today. I cobbled these together from some other sources in terms of what we do. One is our kind of recap from last year, and another is our 25th anniversary report. But yeah, for 25 years, we've worked on everything from farm to fork in terms of dismantling industrial agriculture. I second the descriptions and goals of impact litigation that Sky described. I think it's fair to categorize us as similar in that regard, in how it's very different than normal litigation, what its goals are. It's definitely what we practice. I think that the cases I'll cover today are examples of storytelling and using the law as a tool to move society in a more progressive direction, which is generally how I describe impact litigation. We use state and federal laws, a couple dozen of them overall. We do cases against both federal defendants, state agencies, federal agencies, sometimes corporations as well. And sometimes it's really mixed, where the corporations intervene in your cases to defend agency actions. So it's not often as clear. I think one of the things we pride ourselves on is just like being first to issues and seeing that there's a gap and gap filling, and trying to lead the way in an area where there isn't already people working on an issue. We're proud of the aquaculture litigation as one of those examples. Another one would be, pollinator defense work. Another would be kind of GMO work, among some other areas, I think, in which we have done some precedent-setting work in the courts and otherwise. So yeah, I mean, James and I go way back on aquaculture. You can go to the next slide, the roadmap of what I'm going to cover now. When I was in DC, all this work started at the turn of the century when Department of Commerce started to try to introduce bills that would have federalized exclusive economic zone of federal waters. And, that was the number one priority for Department of Commerce in Congresses starting around 2004 or so. And coalitions of us worked together then, lobbying. Many of you may have been involved in this to stop these bills from passing. It was very powerful opposition because of, like, Don't Cage Our Oceans, the broad array of myriad of interest, commercial, recreational fishing, businesses, conservationists, food safety advocates that were working to stop those bills. And the result of that was Department of Commerce got fed up with trying to pass a law, which they're still trying to do. And proponents of aquaculture asked NOAA Fisheries and DOC to just go ahead with a rulemaking with amending a fishery management plan to allow for industrial aquaculture for the first time in federal waters under the Magnuson-Stevens Act, and specifically their authority over fishing. And so that's the first topic. That's the first case, the one listed there, the Gulf of Mexico. So the rulemaking took 6 years, the litigation another 4 years, so 10 years altogether from 2010 to 2020. The next thing is I'll briefly cover what happened in the aftermath of that from the Trump 1.0 period, the executive order, and then our current case in which we represent Don't Cage Our Oceans, as well as 12 or so other clients challenging Nationwide Permit 56, which I think it's fair to say is basically an attempt to make an end run around the victory in the Gulf of Mexico case. And then looking forward, the next kind of battleground will be this Pacific Islands Fisheries Management Plan, which is essentially an analog to what they attempted to do in the Gulf, but out in the Pacific Islands region. And then the other thing I had listed was the litigation we've done on shellfish aquaculture, which I think is the first litigation of its kind. There really hasn't been a lot. Two things I don't have listed here I would count, and as well as laying out the litigation landscape. One would be, as was mentioned in the chat, there's been the state of Washington banning net pens there. Just like Conservation Law Foundation, there's been groups that have litigated in state Washington waters under the Clean Water Act, challenging Cook and others and aquaculture net pens there successfully. That helped lead to that state ban, as well as the spill. That was mainly Kampmeyer and Knudsen, a law firm, and a former law student classmate of mine from Lewis and Clark, Brian Knudsen, on behalf of Wild Fish Conservancy. And then some work we did to stop genetically engineered salmon, which we characterize as kind of genetically engineered animal and organism work, but really it's an aquaculture case. And this was an effort to for the first time, introduce genetically engineered salmon into our waters. And that was a case that we litigated for about 6 years after, fighting at the regulatory level. And recently, last year, the company proposing it went bankrupt, which again shows kind of the goal of litigation, even when it's risk assessment, rulemaking litigation, is to delay things and cause exposure, controversy, and expense, which hopefully helps lead to the endeavor kind of being exhausted and abandoned. All right, you want to go to the next slide? So the Gulf case, essentially, as I mentioned, without new authority, they were left with their existing fishing authority under Magnuson. And so the case really centered on that. It was an unprecedented scheme that would have basically allowed them to farm more than the annual wild catch for all fish in the Gulf. Were 10-year permits. They would have privatized big sections of the Gulf. That's another impact. It wasn't on Heather's slide, but I think is important in addition to all the output impacts that we address as pollutants, where you're taking a formerly public resource and fencing it off and what was part of the commons and making it a privatized thing, and not allow fishing in those areas. And, it was a test case they were going forward with, where if they had prevailed in the Gulf, if we had not struck it down, the courts had not struck it down, they would have installed it everywhere. Next slide. So we challenged it, a lot of us, and I think I underlined fishing groups there because we filed the case deep in the South in New Orleans and Louisiana, and then we argued it to the Fifth Circuit Court of Appeals, which, if any of you know anything about federal courts, know it's kind of infamous as being the most conservative and reactionary of all the federal courts, even more than the U.S. Supreme Court. At the time, it wasn't as bad, but it was still pretty bad. So we put all the fishing groups really first. The clients included like charter boat associations from Destin, Panama Beach, Texas, Galveston, in addition to kind of Gulf Fishermen's Association and conservation organizations. And, that was part of the storytelling of that case. to put the local fishing interest first there. And we had a lot of arguments under environmental protection laws, the National Environmental Policy Act, the Magnuson-Stevens Act, the Endangered Species Act. But our initial claim was just that the action itself was beyond the agency's authority, or what's called ultra-virus, as James alluded to, because they didn't have the authority to do this, because fundamentally aquaculture is different than fishing. And it's as simple as that. And that was the case. That was the argument that prevailed at the district court, and that was affirmed by the Fifth Circuit on appeal. The story I like to tell from the appellate argument is just simply that one of the judges looked right at me when I started my argument and said, "Now you represent the fishermen, right?" And I said, "Yes, Your Honor." And then he kind of sat back and crossed his arms, and I was like, "Okay, I got that, Judge. Just focus on the other two now." That's the power of the storytelling. Next slide. All right, so this is the key language from the Fifth Circuit, and I think it really underscores the need to continue to stop bills in Congress from passing, and as it's kind of a two-pronged strategy as we do the litigation. It's not in isolation. It really has to be in tandem with stopping new laws from passing in Congress, because obviously if a new statute that is aquaculture specific, amending Magnuson or standalone law that does give authority to the Corps of Engineers or to NOAA Fisheries, that would really change the legal landscape and the framing of all these cases. But as it stands right now, the Fifth Circuit was really, really clear in saying aquaculture is different than fishing, and if you want to change that, you're in the wrong ballpark. This is not your remedy. You need to go to Congress. Okay, next slide. So after that case, and to the extent the Trump 1.0 administration issued an executive order that kind of jump-started a new round of end running that. I think that they were looking at where to go from this, and the executive order kind of a lot of propaganda, and just like the ones that were issued at the beginning of this week. I mean, one thing about executive orders is they can't create new law. They don't have legal effect, essentially. And so, they can command agencies to do things, but the agency has to have some underlying authority. So it doesn't really solve a problem that legislation solves, but it can create time management demands and requirements for agencies to take action, which is what it did. Next slide. And the agency took a bunch of action. One of those was these aquaculture opportunity areas. I'm highlighting this just because there's a current comment period right now. We've got some of the history of it there, but essentially the environmental impact statements are out for public comment for a few more weeks. Those are basically guidance documents that are going to inform where they think they should put, these floating operations in various waters in the Gulf again, or in California. But again, they don't provide any underlying authority, so they don't solve the real fundamental problem that the proponents have, which is what law gives them. If Congress doesn't pass a new law, where do they get it from? So it can just kind of, they can't by themselves support any approval of aquaculture, although they do potentially highlight where it may be if and when that authority is given. Next slide. So Nationwide Permit 56 is the sequel, in my view, to the Gulf case we won. Again, it stemmed from that executive order and a command to the Corps of Engineers to issue this permit, NWP 56, which basically commanded them to approve the construction of facilities, aquaculture structures in the exclusive economic zone of all the federal waters. This is everything you need to operate aquaculture, attached to the seabed and on the high seas of U.S. waters there. And then it was adopted by the specific Corps of Engineer districts. And so, again, as I mentioned, we filed that case on behalf of you all, as well as I think 12 other clients at the late in 2023. And we had, a number of claims under various environmental laws listed down there below: NEPA, ESA, Magnuson, APA, as well as some constitutional claims about whether or not this could go forward at all, similar to what we had in the Gulf. Next slide. And yeah, in really exciting news, we were really buoyed, pun intended, at the end of last year to get this decision in our favor on summary judgment, basically holding that the permit violated two different laws, Rivers and Harbors Act, under which it was issued, and the National Environmental Policy Act, for its failure to analyze the impacts of aquaculture, all the risks that, Heather's slide so vividly showed, the pollution, et cetera, that came forth from the facilities. The government attempted to really just cabin their review to the structures themselves, but not any operations. And we said they couldn't do that, all the, but for the construction, the operations wouldn't take place. And, it's turning blinders on to what it is reasonably foreseeable to come from those constructions. And the court agreed with us. Court didn't reach our ESA claims, but had some nice things to say about it. And it ruled against us on our constitutional claim, but in a sneaky way, we kind of won that claim too, because the court said, even though they didn't need a property right at this time to move forward, they eventually would need a property right. So again, putting another block in the way of eventual development here. In addition to statutory authority, there also now needs to be constitutional authority of giving of the ability to have a property right to set these facilities up before it can go forward. And then since then, the court wasn't clear on remedy and what facilities already existed and didn't. And so we have had a little mini round of briefing the last 2 months on remedy, and I expect a decision in our favor vacating the permit any day now. That just finished at the end of last week. And we'll see what the Trump administration does with that, both as in terms of an appeal as well as on remand, with regards to assessing these risks and what it means for any plans going forward. But a really important precedent along with the Gulf one in terms of what the duties are, what the authority is fundamentally to do this, and where it's lacking. Next slide. This is the next battleground, sequel number 2, whatever you want to call it. This is the Pacific Islands region, and it's pretty much a mirror image of what they try to do in the Gulf, but out, around Hawaii and et cetera. And they're still using Magnuson again. That decision was actually finished in 2022, and we have not gotten a record of decision or a final approval there. We thought we might get it right at the end of the Biden administration, and we haven't yet. So stay tuned on that. But I expect the litigation there will we'll start immediately after that approval is given, which again could happen any day now in terms of that proposal. And again, I think the arguments, because we don't have new authority, they're going to be pretty similar to the 2 prior cases, especially the Gulf case, since they're proceeding under Magnuson again. The next slide. And then on the shellfish side, I think you got to click through here. I'm running out of time and I want to make sure we have time for questions, but I just wanted to highlight this. Obviously it's coastal, so not open ocean, and it's bivalves, other shellfish, not finfish, but it's a form of industrial aquaculture. It's been centered up here in the Pacific Northwest. Nobody was really working on it. So again, it was an issue we took an interest in, and we won our first case on it that we litigated from 2017 to 2020, vacating similarly a Clean Water Act permit, nationwide permit, approving it for failure to assess the risks. And we are currently litigating the sequel to that case. Next slide. Right now, which is a new nationwide permit, but then which was withdrawn, and then now there have been many hundreds of individual permits. Go ahead, click a few more times. Yeah, that have been approved. So I think later this year we'll go to merit summary judgment briefing in that case, addressing this second permit, which didn't fix the problems that the court found in the first permit, and we feel confident about our chances in that case. So it's part of the overall landscape in terms of aquaculture litigation, so I've included it here. And that's it from me.
Awesome. Thank you so much for George, Heather, and also Sky. Excellent presentations. I learned a lot, and I'm sure a lot of folks here have as well. What we'll do is we're gonna, we have officially done the content portion. For those of you who have a hard stop, feel free to jump off, but we also have a few extra minutes here for questions. I know I saw a lot of questions flowing through the chat, some of them being answered, some of them maybe not fully. Casey, I'm going to defer to you on managing some of these questions and seeing if we have any time to get some of those questions. I have one in case folks don't have more, but go ahead, Casey, over to you.
Why don't you start? I wasn't able to look through them while I was sharing. So why don't we start with your question, then I'll.
Okay, mine's just a very quick one to George on what's going on with Westpac. Why are they doing this? Do they hope to get a split circuit decision and have the Fifth Circuit Court of Appeals, like Gulf Fishermen's Association case, now do battle with whatever this one will be called? Is that the idea?
Yeah, sort of. Mostly, I think they did tweak it a bit. I mean, I don't want to get in too much into the weeds, but in the Gulf of Mexico, they created an entire new fisheries management plan that was just for aquaculture and tried it that way. And in the new one, they're taking an existing one and amending it to include aquaculture. I think it's a distinction without a difference for purposes of their statutory authority, but that's what they're going to try. And then, yeah, obviously the Fifth Circuit decision doesn't bind the Ninth Circuit, and so they're going to argue that too.
Great, thank you.
I mean, to your point earlier, Loper Bright and the case law from the Supreme Court should help us because obviously it cuts against deference, although to what extent, who knows, in terms of how much difference that'll make in terms of other factors.
Thanks. Over to you, Casey.
It looks like all the questions that were asked were answered. Do we want to answer some of them out loud, or do people have other questions that they might want to pose? Okay. Well, then in that case, Patty
Well,
asked,
sorry.
oh,
Oops.
go ahead. Go ahead.
Was someone about to ask a question?
I was about to read a question that Patty asked.
You go ahead.
Okay. Patty asked if FarmStand has ever gone up against the certification programs in the realm of false advertising.
Yeah, so I put a response in the chat, but we haven't. It can be tricky to go after certification programs. There's a few reasons for that. A lot of times the certifiers publish their standards online, which can sort of have an impact on the legal analysis of how and to what extent consumers were misled. And then it can be tricky too with like preemption issues because of the linkage between certification programs and the approval of those programs by state and federal agencies. So my understanding is it's a little bit tricky. FarmStand has never done that, but we definitely remain interested in kind of navigating that. And who knows, maybe there will be an opportunity coming up to challenge certifications. So that's a really good point. Thanks for raising it.
I also have a question from Faye. Faye asked, to the extent that the SEC is implicated, I'm wondering if folks have considered securities angles. For instance, Cook Aquaculture is a subsidiary of Cook Inc. Thinking that this has worked for us in fossil fuel litigation / public campaigns.
Oh, is this time for me to talk?
If
Or
you'd like to expand, or if anybody has a response to that.
I'll wait to see if somebody has a response unless nobody does. Yeah, just, it's not always right that fisheries companies have an SEC they're in a SEC under the governance of it, but sometimes there can be an indirect way to target companies. I mean, you'd have to think about how to get standing. I work in coalition with people who have gone out of their way to make sure that stock is bought in every company in order to be able to get access to the public, to the information that shareholders would otherwise get. But, and that can take some long-term just sort of like planning and thinking. But I just wonder if you guys have thought about that. And I see that Andrew is on from Healthy Golf. I know that Healthy Golf has too been part of efforts that have been connected to the SEC sort of looking into the securities angles.
That's really interesting. We haven't at FarmStand to my knowledge. So that isn't something I can speak to in any specificity, but I will say I think that's a really good idea. And I think that in litigation, it's really important to see whatever's working in like the fossil fuel litigation space, maybe we can use that in a different context. Oftentimes the law can be a little bit transferable that way. So yeah, definitely really interesting. I'm not sure if the other presenters have ideas or thoughts, but.
And then the other thing I'll say is in connection with litigation, this is obviously a strict litigation conversation, but there are other ways to defeat, right? There could be, you know, public campaigns work.
Mhm.
They work. And I'm sure y'all work in coalition with other groups. So it's probably something that I definitely put on the list of things to think about.
Yeah, with the genetically engineered salmon, we did a big campaign along with lots of groups. Friends of the Earth was one of the leaders of it, to boycott any restaurant or grocery store sales and get grocery stores to agree to not to sell it if it ever became commercially viable. It never did become commercially viable, let me be clear, but had it, we kind of had set up like 150 different retailers and other entities, corporate entities, through pressure to not sell it. And so it was definitely part and parcel of the kind of litigation and sistered with it in that way.
Thank you.
I'm also wondering, Andrew, if you had anything to add to what Faye had mentioned around the SEC. Just giving you an opportunity to chime in. You're muted.
I don't. I'm sorry. I read Eastern time wrong, and so I've come in after most of the call has happened. I don't have anything about the SEC. We're involved in a permit lawsuit for a Florida net pen operation, but that's all I can speak about.
Thanks, Andrew. Not to put you on the spot. I have a couple comments, questions. One, thinking about Cook Aquaculture and the idea of pulling together our various allies across the borders. If anything around the Lacey Act would also fit into the Cook Aquaculture. I don't know where they're taking the fish for processing, but if they have processors in Canada, if there's something that would be able to influence some of the cross-border activities and just to like overall weaken Cook's stretch and their reach. So that was a specific question, and then I was going to respond to Stephania's comment about international legislation.
The main net pens, all the processing is done in Maine.
Thanks. And then just thinking about Estefania's comment about international litigation and thinking about, years ago when there have been challenges against anti-dumping within the WTO world, and if any of you have been looking into those type of opportunities to try to impact aquaculture that's happening in destructive ways in other countries and coming in. And I know this is a little bit outside of the scope of this conversation, but just building on what Estefania's comment was.
Yeah, we haven't, I would just say for CFS, it's not something that we've worked on. We're aware of it, obviously, and I think it would be a different tactic and an important one from the perspective of labeling. You could see something like federal requirements on imports or otherwise through Magnuson, for example, for products coming in. But I think as far as I know, besides labeling work, right to know work, there hasn't been much in the way of other efforts in that area from our sector to this point.
Thank you. Thanks.
I just thought I'd mention, because of the question regarding, there was the talk of false advertising one, and so I'd love to hear if people have ideas as to the basis for false advertising claims, because it becomes very complicated with Cook and all the different brands they have and what exactly is written on their packaging. And we have not seen anything blatantly false yet, but if some I mean, there's so many brands, it's absurd and it's tough to get a hold of. We're obviously very busy right now with our Clean Water Act case, but I do, in my program, I'm looking into greenwashing cases against all different types of companies, plastic water bottles. We looked into, we're running the gamut, but we have to pay attention to the current greenwashing cases that are out there, and consumer protection cases, and who's having success and who's getting dismissed pretty quickly. And it's all over the place right now. Not feeling too good for the state of New York and on both her JBS and her Pepsi Frito-Lay case, because those didn't make it past the first stage of litigation. So but I am also hoping that if we continue through litigation with Cook and we're able to have access to internal documents, that could unearth something, another great potential case. And because litigation breeds litigation, in my view, and we'll see what happens as we walk through this matter.
Yeah, I'll just
Yeah.
add, I think, oh, go ahead, George.
Go ahead, Sky.
Okay, I was just going to quickly add, I think one of the sort of public claims that has kind of gained traction in terms of consumer cases is just the representation that your products and practices are sustainable, right? And all variations of that representation. I think there's been some really good consumer perception research done to sort of confirm that consumers, when they hear that term or that phrase, they think it means a certain thing. And then the producers obviously are not meeting that expectation with their practices and products. So I'm very optimistic that there could be good law coming down the pipeline in terms of being able to go after companies for their sustainability representations.
Yeah, I agree with that. I think it's a developing area. We're also interested in looking at it. We've done some right to know and greenwashing cases in other factory farm areas, not aquaculture. I will say the limitation on these types of cases, though, is that they don't stop harmful conduct, right? They stop misleading labeling, which is important and can change consumer behaviors, but it is different than equitable relief cases where you stop harm from occurring to begin with or end it from occurring.
Yeah, I'm working with a colleague who was on one of the flushable wipes cases that they won, and then they just won. Their relief was that flushable came off the wipes, and everybody was like, "Yay!" and consumers will still flush them down.
Big case in point. Thank you. That's well said.
Casey, do we have time for one more question?
I think so. If Laura,
Okay.
would you like to ask your question out loud, or would you like us to just read it for you?
Thanks. I was just interested in the feasibility of litigation in regards to Class 5 wells. These are a little different than NPDES permits, but these all came about because certain towns want to treat their own wastewater. They're not sending it to Deer Island in Massachusetts. They've got enough money in their town to create their own wastewater treatment center, and they're injecting it into the aquifer. There's 26 communities in Massachusetts doing this that have permits, and there's another 350 private injection wells. In my community that I live in, we've had a 2-year water ban because of PFAS in the drinking water. And, some of us believe that it might be because of the injection well. But when asked the Board of Health if they would test it for PFAS, they said no, because they know it's contaminated. So I'm just curious as to whether or not there's no narrative provisions in that type of permit, because you can't see it, like you can in the open water. So that's really what my question's about.
I do not know. I mean, I'm in Massachusetts and I don't know. I haven't looked at one of these permits. I don't think maybe for years. Are they current? Are they expired? Do you know?
They're current. Yeah,
They're
they're
because the new permits, well, the new permits that were coming out or were drafted in the last couple of years, there was contemplation of including some PFAS measurements, sampling and monitoring, not necessarily limits yet, but so I'm wondering if there's the potential for commenting on the permits, and Mass DEP is issuing these.
yes.
Yeah. And getting on their case about what's included. I mean, somebody's got to start testing both the soil and all the water around in the aquifer.
Right. There's legislation that's been submitted Friday, again, in regards to stopping the spread of sludge on the farmland and any open land in Massachusetts. We're still contaminating ourselves with injecting wastewater into our wells. So just wondered about that because it sounds like NAMPDs will test for permitting for PFAS, but not these.
There's always a potential for change, I
Yeah.
think.
Well, thank you, everyone. Thanks for your questions. Thanks again to Heather and Sky, and I know George just left, but thanks to him as well for attending this session. I hope that DCO2 members and allies got something out of it in the sense of connecting some, even if they're planting seeds for now, right? We just want to see like ways of connecting the dots here and ways that you can use litigation as a way to advance your organization's goals. And so with that, I also want to just let you all know that NFFC will be planning a similar webinar to this, a little bit more ag focused, and we'll be in touch with Antonio more on that later. But again, thank you everybody for coming today, and have a good rest of your day.
Thank you.
So
Bye.
nice to meet you. Bye.
Bye.